Hello and welcome to our occasional series of video podcasts with the overall title, People, Behaviour and Governance. Today we're right on the governance end of the spectrum and we're talking about the latest updates to Jersey's AML CFT regime, particularly looking at what's been done in relation to the scope of Jersey's AML laws as a result of its impending Moneyval visit. We've asked two subject matter experts to come in today. So I've got Rob Milner, who's a partner in our funds team, and Oliver Lindop, who's a counsel in our regulatory team. So Ollie, coming to you first, what's changed? What are the key things that have changed?
Many thanks, Hugh. So what we're dealing with here is the most significant change in the Jersey AML landscape since the inception of the regime back in 1999. There's been a modest expansion of the overall what we call Schedule 2 scope, so the scope of entities which are subject to AML regulation. But perhaps the most impactful change is the sweeping away of a number of AML scope exemptions and registration exemptions. So for the first time, as of this year, all businesses in scope for AML regulation in Jersey must be registered with the JFSC. So what that means is that all existing AML regulated businesses must complete a workbook to update the Schedule 2 categories within which they are registered, and this must be done prior to the 30th of June 2023. And newly in scope Schedule 2 businesses must register, and these steps must be taken before the 30th of June 2023. There's a transitional period running to the 30th of June 2023 with there are two minor exceptions. The first one is for entities connected with family offices, and the second one is connected with directors who are in scope for AML regulation for the first time. Those people have got until the 30th of August to register.
Okay. Now, and what's the reason for all of this? Why are we doing this?
So Jersey's AML regime was introduced back in 1999, as I said, and there have been incremental changes since then, with the most notable interim developments having been in 2008, which is when we saw the introduction of the Supervisory Bodies Law, which for the first time gave the JFSC regulatory teeth in respect of AML matters. But by year-end 2021, which is when we all started thinking about the amendments which have now come into force, it was definitely the right time, almost a quarter of a century on, for a holistic review of Jersey's AML regime. So in respect of scope exemptions, it is true that the position had become a little unwieldy, with exemptions having been introduced over time under disparate pieces of legislation and crucially, without being subject to the risk assessment methodology which the Financial Action Task Force, which I'll call FATF, now prescribes. So the primary registration exemption which existed before was for those businesses which were provided with services by an existing Jersey trust company or fund services provider and had no other place of business in Jersey other than that service provider's premises. Those entities were able to use a registration exemption, which meant that while the JFSC was their supervisor, how did they know that they existed? So for the first time, the JFSC, or at least from the end of the transitional period, the JFSC will have a full list of all of the entities for which it is AML supervisor. It is also a feature of offshore life that one bad proceeds of crime case let through the perimeter could cause lasting damage to Jersey's reputation and the financial services industry's future prospects. So part of what these amendments are about is ensuring that this doesn't happen. And of course, Hugh, as you've already alluded to, these changes are designed to ensure that Jersey's AML regime compares favourably to that of other jurisdictions, peer jurisdictions. So this is with an eye to Jersey's Moneyval assessment, but also motivated by the policy imperative of the government of Jersey and the JFSC to protect Jersey's regulatory perimeter.
So Rob, coming to you, is it correct to say that this is just more AML and more compliance?
To an extent, yes. I mean, from my perspective, being a funds lawyer, a lot of things that we were dealing with were already in scope. So all public funds, nothing's actually going to change. And all the functionaries of public funds, nothing's going to change. They were already in scope. They were deemed registered. They will continue to be deemed registered. They'll get the workbook that Ollie referred to. But by and large, there's going to be very little change for public funds. Private funds are a different kettle of fish. For many private funds, they relied upon exemptions, so certainly the functionaries to those funds relied upon exemptions, which have now been taken away. And so we've got to really look carefully at those structures to see if they truly are funds and therefore truly in scope, or if they're things like joint ventures writ large. And so to the extent there's more AML, there will be more AML, but a lot of it will be duplicative. And so you've got existing structures which were public, where it's already being done, and you've got private structures now being brought into scope, where after the sort of initial triage and working out if they are in fact in scope, you look at what wasn't being done before and what should be done as well now.
Okay. And those exemptions, Ollie, are they going to be back, do we think?
So as I alluded to in my earlier answer, the AML exemptions which we had up to the 30th of January, and there were approximately 100 of them, were arguably not FATF compliant because they hadn't been subjected to the FATF's AML risk assessment methodology. So the JFSC has clearly stated that some exemptions might be reintroduced in the future if a case can be made for them. So we do expect some of the exemptions to come back, but there is work to be done. A final point on that, there are some exemptions, with examples being the exemption for trustee of a private unit trust and the so-called PTC, private trust companies exemption, which arguably were not needed in the first place because those activities are not conducted as a business in any event. So there were some exemptions which existed for the avoidance of doubt. So arguably life continues as normal without those exemptions. We just need to focus on our analysis.
And in terms of controversy, I mean, these amendments haven't been uncontroversial. I mean, you touched on the idea of conducting service as a business there. I mean, that's one of the aspects of these amendments that have been quite controversial. Is that right?
Good question, Hugh. So that I think any circumstance where you're imposing a greater burden on people is going to be controversial. As Rob's alluded to, there's a balance to be met with compliance versus commerciality. But the key issues which I have found to be controversial are the application of the AML amendments to family office-related entities and the non-executive director sector. So the JFSC very helpfully provided some clarity last week in respect of family office-related arrangements. And this goes back to what I was saying about the private trust company exemption. So arguably, that exemption existed for the avoidance of doubt, because where you have a typical trustee entity associated with a family office, let's say looking after the affairs of a single family or a couple of related families, our starting point is that is not an as a business arrangement, and that's applying the JFSC's own indicia from their own statutory guidance. What happened on Friday is that the JFSC put out some additional frequently asked questions for the family office sector, which has just helped to allay some of these concerns. We might come on to those in more detail depending on what other questions you have for me. But another area which has been controversial is the NED sector. So what we mean here, we don't mean directors who have a Class G TCB license in their own right. We don't mean those who are employed by trust company providers or fund service businesses and are then provided to client entities. We mean the ones that stand alone, and until the 30th of January this year, they were able to take advantage of what we called the 6 or fewer exemption. So that exemption still exists. If you hold 6 or fewer directorships, and there's a counting methodology to get to the 6, which we'll leave to one side. If you hold, if you fall under that, you still have an exemption under the financial services law, but crucially, that's no longer carried across to AML. It's one of the ones the giant broom has been taken to, and they've been swept out. So those individuals are looking at being in scope for the first time, fully in scope, no light regime, got to do CDD on the entities which they're directors of. They've got to have policies and procedures, business risk assessment. So those individuals are looking at this and thinking, is it worth it? So it is possible that we might see the pool of non-executive directors, who are some of the most experienced people we've got, who add value and act as gatekeepers, to any Jersey incorporated entities. That they might be looking at the amendments and thinking, is it worth it? Is it worth carrying on? What I would say to those people is, you are going to be in scope, although the JFSC is going to try to help by improving on the frequently asked questions, which is already published, as to which the version which has been published, I think it's fair to say, does have some mistakes in it, which need to be corrected. But we think there are opportunities for folks, directors newly in scope, to look at things like reliance upon any co-directors who might be doing CDD, perhaps even joining an established financial service business and becoming an employee, so that they don't have to, let's say, do AML on a standalone basis.
And in terms of how businesses go about that assessment in terms of are they in scope or are they not? How do they go about that?
So that hasn't changed to you. So fundamentally, back to the start of this regime, if you were looking at any entity or arrangement and looking to perform a Schedule 2 analysis on it, we say that there's a three-prong approach. You start with jurisdiction. You're asking yourself, is the entity conducting its business in or from within Jersey? Now, that jurisdictional test isn't contained in the Proceeds of Crime Law. It actually is contained in the money laundering order, which isn't quite ideal, but that is the accepted practice. Number two, you go on to look at the activity. Is it a Schedule 2 activity? So you're looking down that list of 24 activities, which is listed in Schedule 2, and looking at whether the activity which the entity is performing matches up to any of those. With care to be taken on the exact wording, because there are some inconsistencies in how those activities are drafted. Only if you feel that you're within the jurisdiction and you're conducting you are conducting one of the activities listed in Schedule 2, do you move on to look at the as a business test. So only if you're performing that activity on a commercial basis, with profit being perhaps the key indicator of a business, will you be caught. This is with one exception, which is the Schedule 2 paragraph 25 activity, acting as a non-professional trustee. But those businesses or arrangements are not subject to the full spectrum of AML obligations. They're subject to a light regime.
Is there a problem, and coming to you, Rob, that some of this is pretty subjective in terms of some of the tests in, say, the conducting service as a business?
Yes, it is. And so the guidance is helpful in some regards here, but less helpful in others, as one might expect from a regulator. They're not going to say everything's fine, because there are clearly some things that need to be brought into scope. But the issue we've had with lots of clients is where you're on the borderline, because Schedule 2 now has lots and lots of paragraphs, and a lot of them say very similar things in slightly different ways. And so trying to work out what your activity you might be undertaking that could be in scope is very challenging. And so what we have done is created our own sort of triage questionnaire, which takes you through the key concepts that Ollie outlined. So are you doing it in within Jersey? Are you doing it as a business? Because we find that to be a very, very high-level filter. And you can come to some very interesting conclusions based upon whether on a subjective analysis you have customers or not. Because the vast majority, and what people were worried about here, is that lots of SPVs will be brought into scope. Because what it's really aimed at is things like, funny enough, family offices, where they didn't have a regulatory touch point in Jersey. They could sit there in an office somewhere in town and just not be known by anyone because they weren't administered by someone regulated. They were entirely self-sufficient. They were out of scope due to an exemption for AML registration purposes. Now that's gone away. You sort of focus on, well, actually, what businesses should be in scope and how do you get to the position where you can take a sensible view. And it is very much, you look at the underlying intent of the law, what's it trying to catch? And it's trying to catch stuff that doesn't have that touch point. So if you've got a more SPV-style structure with an existing administrator that's been set up for, as the name suggests, a special purpose, the instigation of that structure and the operation of that structure is effectively in-house in a number of cases. There's just no third party involved. And it's administered by someone. Someone has treated that as a customer. So it's sensible to say, that entity, it doesn't have any customers. It's wholly owned or it's owned by a joint venture. And one of the most helpful positions we've been able to get to and gets lots of things away from the need for registration is by saying, is this something that actually has third parties or customers, or is it actually a private structure that's been set up to do a specific job? And actually, it takes us back because a lot of these structures are set up as what's called professional investor regulated schemes back in the day, because it triggers a number of exemptions. For lawyers, it was an easy out. It was like Christmas. So we could say a vast range of structures were out of scope for financial services law purposes and didn't require the general partner or trustee to be regulated because effectively it was a structure that met certain key regulatory criteria that the JFSC had said, okay, we're not interested in those. Now that's gone, and admittedly, it's important to note the exemption is still in place for financial services purposes, but it's gone away for AML purposes. You need to review these structures and say, well, actually, did they need this status in the first place? And so you go and say, well, actually, this general partner of this partnership, we made it a PERS because we didn't have to think about the regulatory analysis, and now we have to think about it. And we have to take a sensible view on whether it is actually performing these things under the financial services law, which then tracks through to the concepts in Schedule 2. And if you look at it in a certain way, from very many structures, you say, well, actually, no, this isn't doing it as a business. It never really should have been a person in the first place thinking about it. But we did it because it just made it clear that exemptions applied. And now the AML exemption's gone away. We looked at if it was ever needed in the first place. If the answer is no, you're out of scope.
And Ollie, what are the pitfalls you've seen people fall into with this analysis? What are the big mistakes that people make?
So good question, Hugh. And some of this follows on directly from what Rob was just saying. So in my experience of practice, regulated financial services businesses in Jersey do have a tendency to overdiagnose Schedule 2 status. And the reason for that is perhaps, skipping over the jurisdiction test or skipping over the as a business test. So we do think that there's a need to take care and not, overdiagnose Schedule 2 status. Stepping back, Jersey regulated businesses are very good at spotting the sorts of things which might be close to being Schedule 2, which is businesses broadly or any kind of arrangement which handles client money or takes in funds from other people. But there are some activities which just aren't Schedule 2. So a good example of one we've seen recently by one of our clients is that they'd concluded that a property holding structure where that property has tenants renting units in the property was a Schedule 2 business. Now, of course, there is an AML risk associated with those rental payments coming in, and a degree of compliance monitoring ought to be undertaken as a result. But that doesn't make the property holding entity a Schedule 2 business in its own right. So that's a good example of what I call overdiagnosis.
Okay. And what about the AML service provider regime? That's changed and appears still to be changing, doesn't it? Depending on, which guidance you read.
That's right. It's not quite settled, Hugh. And for example, there's a hole in it insofar as non-professional trustees who, as I've previously mentioned, are subject only to an AML light regime, are not permitted to appoint an AML SP. So, we don't really understand what the logic is
and
there.
They're probably the entities that will need most help, you would have thought.
Well, exactly right, because they'll have the least expertise, and they've been the JFSC hasn't been particularly active in enforcing the NPTO regime, which hasn't come around as a result of this round of amendments. It's actually existed since an order was introduced back in 2016. So it really, AMLSP is, in overall terms, rebadging something that has always been done. Jersey service providers have always undertaken AML on behalf of their client entities. This is about putting it on a more formal basis. And in circumstances where there's a failure or a breach, that is now, the intention is clearly to hold the service provider responsible for that. So that's one of the key aspects of it. But still settling down, and clearly there's going to be work to be done over the medium to long term to recognise this new regime in, for example, admin agreements which businesses have entered into with their customers, just to make sure that they're up to date, using the latest technology, the latest terminology, and fairly reflecting the the increased responsibility which has been ascribed to the service provider.
And Rob, we touched on this at the beginning in terms of the international element to this. Obviously, we're always under scrutiny from Moneyval. Mm-hmm. Is there a danger that Jersey will become sort of less competitive compared to other jurisdictions as a result of these changes?
Well, as I say, for what I do, there's not actually going to be much change. So for the funds industry generally, public funds were always in scope. Private funds, we had the designated service provider concept, which actually is the genesis of the AML service provider concept. And so all they're going to do is put on another hat and do what they were doing anyway, frankly, in the vast majority of instances. SPVs under funds are out of scope because we've established they don't have a customer. So in terms of what I do, the impact is mainly going to be felt by things that we cannot categorize correctly as joint ventures. And so things that actually a quasi-fund and sort of smell a bit like a fund and would have been out of scope before by virtue of exemption, but they're now brought into scope. So for those structures, we need to take a careful look. But for the vast majority of what I do, the scope is now actually fairly clear. And it's just dealing with the consequences for various clients and making sure that they have all the paperwork lined up and all the assessments and analysis that needs to be done has been done. One of the interesting things we are seeing is that the JFSC are now, every time you set up a new structure, they are asking the incorporating entity whether you've considered the Schedule 2 position or not. And so I'm getting lots of emails, not necessarily from clients, but from administrators who are setting these things up for clients. And they're saying, we've done our analysis, but actually, we just want to double check we're on the right lines here. And so it's something that people are now having to think about every time they think about entity.
So think about it and document it every single time. Is that the key?
Yeah, and that's it. And so it doesn't mean you actually have to do stuff in terms of actual, follow-on, but you have to think about it. And that is actually, to me, the biggest change. It's now put this sort of piece of analysis and this piece this piece of legal work at the forefront of the mind of administrators as well as clients, whereas previously it was just done in-house and they sort of ticked an internal box and you very rarely saw the actual outcome of that.
And I suppose there's a question for you both, but how do sort of Carey Olsen support clients in working this out?
Well, we've got our wonderful tools. So I mentioned this before. If you go onto our website or if you go onto, we posted it across LinkedIn, we put it everywhere we can. We actually have a click-through tool. Which, it's not definitive. It's not designed to cater for every scenario, but it gives you a good indication of whether you're in scope or out of scope, or if you're a borderline case that needs to be looked at very carefully. And that's the key thing, because a lot of structures, it's going to be really easy. They're either really obviously in scope or really obviously out of scope. But the sort of borderline cases are the ones that need thinking about. And so we were very happy to put out this tool. We could have charged per use, we could have charged for access. We didn't want to do that. We want it to be out there so people can get the easy answers. And then when they get a hard one, they come to us to ask.
And who should they be asking at Carey Olsen if they?
We've got a whole team of it. So anyone on Ollie's team, or anyone in my team, or me, or Ollie. And but we've been undertaking internal training. We've got a number of senior practitioners across various departments, because this is really a pan-firm thing, because it impacts us so many potentially different ways. So we're very lucky that we've got a number of people who are completely up to speed and who know exactly what they're talking about on this.
Okay. That's right. And particularly, Hugh, as we come to the sharp end of the transitional period, I suspect that regulated businesses may have left the harder cases until last.
Yep.
So we're expecting to be quite busy in
I'm cancelling my holidays for May. Yeah.
Okay, that's probably all we've got time for, so we'll leave it there. Obviously, if you'd like further information, the toolkit's on our website. If you'd like to speak to a human being, please do get in touch with either Rob or Ollie, or your usual contact, Carey Olsen. Otherwise, we'll be back soon with another in our series of People, Behaviour and Governance. And if you've got any suggestions for future topics, please do let me know.